do you then distinguish between what the realists did and what is coming with critical legal theory? What is it that has been added to that decoction, or what is the different direction in which from realists, the critical scholars have gone? What is it that they have done? Subjectivity was acknowledged by the realists. What kind of subjectivity were they acknowledging?
And subjectivity, basically, do you understand what we mean by that? That is, that as an individual, I have a
set of personal choices, preferences,
experience, whatever you want to say. So how I think, you don't think. How you think, you don't think. So all of us have a different take on the same thing. Now, the objective theory is saying everyone can understand law in this one way.
And everyone thinks in the same way.
And there is no other way of doing it. So leave your experiences aside, leave your preferences aside. This is the way to think about law, and that makes it like this is how it really is, and you color it by your experiences, you are biased or you are not getting it right, etc. So it is possible to think about something in abstract out of its context. So law can be law irrespective of whether you happen to be in India, or you happen to be in England, or you happen to be in Africa. So everyone can subscribe to the definitions of a Austin or a Hart or a Dworkin and the rest of it, because their definitions are not dependent on that they are in a country, they have a language, they have an economic system, they have a political system. Now, subjectivity on the other hand is an idea which you could sometimes call bias. But it's not bias, but that's the closest I can think of. So when feminists come along, for example, and say, hey, the way you are defining law doesn't ring true to me as a woman, what has been the response of the mainstream legal establishment? You are biased. That is, you want to bring in the fact of your gender difference, when really we are not talking of gender at all. How does it matter whether you're a man or a woman when you're talking about legal theory? How does it matter whether you're a man or a woman when you're talking about constitutional law? Does it matter? Tell us why.
And for example, when I look at reservation provided in the Constitution, if I am reserved under that category, I will see it as an advantage, whereas people outside those category would see as an oppression or disadvantages on their own part. So.
Yes. So basically, then this is something that the Constitution is at least acknowledging. So basically, what we're getting at is which side of the divide you're standing on will make it look like an advantage or a disadvantage. Now the point is that how would a constitutional lawyer explain it? They will not explain it as an advantage or a disadvantage. They will say the Constitution is about upholding the right to equality. The right to equality sometimes requires that special considerations are made for certain people who have been disadvantaged in the past. So they have a language which makes it look like that it is not to do with you and me and which side of the divide we are standing in. They are saying the principle is that of equality, and our means of reaching that equality is to acknowledge past disadvantage and rectify that past disadvantage by means of reservations or whatever. Now, the problem with this kind of analysis is that you're telling me as a person who is protected under these reservations that we are doing you a favor. That everyone else is equal, but you poor thing, you've been disadvantaged, and we are so good that we'll let you have a little bit of a bite at the cherry also, and it is a largesse that we are making available to you so that you can pull yourself up. What if the story is not quite like that? What is the story is that you guys are the ones who have been exploiting me and my family for generations. And it is time that you actually acknowledge that you are undeserving beneficiaries of a system of exploitation. And it is about time that you gave up your privileges and let me have equality for the first time in my life. Two stories describing the same situation. The point is that we are so ingrained in the first story that we don't even acknowledge the possibility of the second story. Now, what critical legal scholars are saying, you can only start acknowledging the second story when you understand law, when you study law in its wider political and economic context, which is what the mainstream theory is not doing for us. Mainstream theory is saying law has nothing to do with everything else around it. We can talk of law without having to worry about what the political, social, and economic situation is. But if you bring into the picture the political system you have, the society you have, the economic system you have, and then connect it to the kind of legal system you have, you begin to see a wider picture. So the first point that critical legal scholars are making, and which wasn't made by realists, is that you have to study law as an aspect of the political and economic system. This is what Marxists were saying also, but they were saying it in a more, if you like, fundamental. Yeah, so their if you like, their aim was that capitalist system has to be replaced by a socialist system, and we don't need to go there. But the critical theorists are saying just because we don't need to go there doesn't mean that capitalism has delivered the goods that it had claimed to do. So what are we doing? We are actually wanting to critique the assumptions of capitalist system which exists in a liberal political system. So do you see the point that political, economic, and legal systems go together to constitute our society? So the first big change that is happening in critical legal studies is that they are the ones who are saying you cannot study law in isolation from its political and economic context. Okay? Now, what is it that they mean by political and economic context? So, on the outline I had said to you that there are two streams of critical legal studies. I'll come to that in a minute. But basically, when they're talking about that you have to study law in its political and economic context, they are saying that liberalism stands for something. What liberalism stands for makes it sort of logical for us to conceptualize legal system and legal rights in a certain manner. So let's go back to liberalism. What do you understand the liberal political system to be? You're part of one. What does your political system stand for? Yeah.
Minimum control by the government and maximum governance.
Maximum
Governance.
Governance.
Implementation of what law is there and minimum laws to interfere in the personal matters of a person.
Very good. What also I also want you to sort of think about is that liberalism is an enlightenment philosophy which is basically saying, which is giving effect to this notion of all human beings being equal by virtue of being human. So this is kind of replacing our earlier understandings of human beings being born as upper class or lower class, etc., and having rights determined by which strata of society you were born in. So when Enlightenment thought comes and gives rise to liberal political philosophy, the fundamental idea of liberalism is equality and liberty. That is, if we are equal human beings, then there is no justification for anyone curtailing my liberty. I'm as equal as you are. Who are you to tell me that you can do X but not do Y? So if all of us are equal, then where does political authority come from? You see the point that I'm trying to make? Where did political authority come from before enlightenment? The king had a right to rule over me. Why? Because it was a God-given right. It was a birthright of the nobility to rule over the rest of the people. We have thrown out that notion. So we don't have access to that legitimation of political authority. So what are we going to do? Okay, so we have to create political authority. How do we create political authority amongst equals? Is by using this fiction that we have all agreed that there will be political authority, and the authority of the state then is dependent upon my giving up my liberty. That much is clear? Okay, if I have decided to give up my liberty, I haven't decided to give up all my liberty. I've decided to give up the minimum amount of liberty which will facilitate the creation of a state. Okay, so this is where liberty comes in. What is the scope of liberty in this kind of a political system is, state has legitimate authority to make laws and curtail my liberty only in the area where I have given it the authority. Every other area remains the area of freedom, liberty. Freedom from what? By the state. So by the law. So the argument is that laws can regulate certain areas of our life because we have agreed to be regulated. Every other area of our lives has to be without regulation. So this is what is meant by liberty and regulating interference by the state. That the idea is minimum interference so that people's liberties can be maintained. All right, what kind of a legal system can you imagine in that situation? A legal system that enforces people's rights, or just to narrow the discussion, the concept of fundamental rights. That is, I have certain fundamental rights that nobody can take away, not even the state. Why? Because I did not agree to give them up. Right? I agreed that the state can police, that state can tax, that sometimes the state can do a few other things, but I did not agree that my fundamental rights can be curtailed. All right, if my fundamental rights cannot be curtailed, then you can say that the role of the state is minimal in that it should enforce my rights and it should make sure that law and order is maintained, that is minimum security is maintained. Now the rights that we are talking about here is what critical legal scholars are focusing on in a major way. They're saying your concept of rights is hugely problematic. So what I'm trying to say to you is how rights are conceptualized is necessary in this conception of a liberal individual. That is, liberal individualism demands that individual is the holder of rights. And the purpose of these rights is basically to curtail the authority of the state. So this is what constitutions are there for. They are to protect the individual from the power of the state. So the state cannot make any laws that it likes. It can only make laws where I have conceded authority and there are areas demarcated where state cannot curtail my rights. So fundamental rights is no-go zone for the state mostly, and other rights are basically then the question of how will I decide what kind of laws to make. There comes the liberal principle of how do liberals justify making laws is by the harm principle. Yeah, do you make the connection? So this is what the harm principle is doing. It is saying, look, it is necessary to curtail people's freedom. Complete freedom doesn't make for a society, but we also have to make sure that the state doesn't overstep its boundaries. So what will we say? The state can curtail my autonomy so long as I do not harm another autonomous person. Fair enough? So what critical legal scholars are saying, focusing very much on how do you conceptualize harm.
In a very simple way, harm would be encroaching on somebody else's rights.
Else's liberty, basically. Yeah. So as long as my conduct does not curtail your liberty, I'm free to do whatever I like. The moment I curtail your liberty, the state has legitimate authority to restrict my conduct. Now, one way of doing this is for the state to use the public-private divide. That is, in public areas of our lives, the state can make laws. What are private areas of life remain outside of regulation. Grasp this very, very clearly. That in public areas of my life, laws can be made. In private areas of my life, basically, the state should keep out. What about the harm principle in the private area then? What do you think? Does the harm principle operate in the private area of life? Why not? This is what critical legal scholars are saying, that how you conceptualize harm and where it operates itself is the problem. So, domestic violence is a good example of that, that historically we have said, private area of life, not the business of the state, not the business of the law. Why? Because it is private. And why is private protected from state intervention? In the name of, we never gave it up, and in the name of liberty, same thing. So do you see how we are setting up a system where legal regulation of certain conduct is okay, legal regulation of other conduct is written out of existence by using certain concepts like liberty, private sphere, harm, etc. All right. So what the critical legal scholars are saying in various ways, I'm just using one example, is that how you understand harm itself is problematic, how you divide public and private itself is problematic, and what kinds of laws you make in that regard then shows that you're trying to maintain male privilege. So how are you trying to maintain male privilege in this area? Is that you have first defined that private sphere is area of no regulation. It is an area free from state intervention. But think about it, in our private relationship, what's happening? I have no rights. So that is the point, that I have no rights because it is an area where law does not come. Who suffers? Majority of the time, domestic violence is happening. Yeah. So you got the connection. Similarly, caste-based violence. If caste is something that the religion authorizes, the argument then becomes it is an area where the state does not intervene, should not intervene in the name of what? In the name of religious autonomy. So then the argument has to be, we need to reconsider what do you mean by harm, why it is not applicable to the private sphere of activities, does religion fall under that, do private relationships fall under that or not? Okay, as lawyers, are we taught to do all that? And if not, why not? So critical legal scholars' argument is that the rights discourse is a way of maintaining the current privileges. That is, it is in the name of rights that you are maintaining social inequalities, yet able to claim that what we are doing is enhancing your liberty, maintaining minimal state regulation, and basically giving expression to the idea that state should not be intervening in people's lives if it is not required. And by definition, we have made it that it is not required in this area because harm principle doesn't apply here. What a web we weave. If we keep subscribing to this way of thinking, are we responsible for the state of affairs that we are part of? Can you seriously say that it has nothing to do with me? Why is it not the way that you are taught law? I think you should be asking all your law teachers. No, I don't mean that. But at least I want you to start thinking for yourselves that the way we understand law itself is maintaining the system, making it look legitimate, and making it look like nothing needs fixing. So critical legal studies is fairly sophisticated and it does a lot of things. But the point that I'm making with their critique of rights discourses to see that normally speaking, as lawyers, we are told that this is what the legal system is there for. It is there for protection of our rights. What critical legal studies is saying is, look very carefully how rights are conceptualized, which rights are protected, and how certain areas are considered not even subject to the rights discourse. So, in Davis's book, he gives us 3 examples of the areas of law where we can examine that. She talks about contracts, she talks about torts law, and she talks about, I think, criminal law, but I forget. But I would like very much for you people to go and read that for yourselves because it is fascinating reading. It is something you will not read in those mainstream books on contracts and torts and the rest of it. No, in Davis's book, in this chapter on critical legal studies, towards the last part of the chapter, she's giving us 3 illustrations of how critical legal scholars have critiqued the discourse of contract law, the discourse of torts, and one more. I can probably find it for you. Okay, I'll let you identify it, or I'll tell you tomorrow. I don't want to spend more time on that. Okay, with regard to torts, what is our understanding of torts law? Normally speaking, what does torts do? It compensates for civil damages against whom mostly?
Against individuals.
Against individuals, yes, but my neighbors, yes, but most of the time torts has to do with employees in the sense that the historical development of torts as a doctrine, and it's mostly doctrine developed by judges, is that it became sort of necessary with the rise of industrialization. With industrialization came certain ways of doing industrial production that employees became subjected to new kinds of risks. So if employees are injured in the process of work, should they be entitled to any compensation or not? The argument is that the torts law developed. Remember this is something very significant, that it is the judges developing the law of negligence and saying that everyone has a duty of care. what could be better than that? So we did not have a concept of duty of care, and we are creating it. These are the same judges who we've been criticizing for last so many days. So it must be a good thing. Sure. What critical legal studies is saying is, when you actually analyze what the outcomes are in torts cases, you realize that it is a means of containing the cost of industrial accidents. So rather than making it that the employer goes bankrupt because his factory injured X number of people or injured people in a certain manner, we will contain the cost, we will designate what is reasonable damages in this area. So one of the articles in your book, actually it's not extracted, it is just mentioned, is that critical legal scholar, someone called Abel, has provided an analysis of torts law to show the function of torts decisions was that people who already had a lot of money could actually generate or were awarded higher damages than people who did not belong to the upper classes, upper economic classes, and were injured as employees, were actually denied similar kind of damages. And what kind of damages were made available against the employer was actually working as a way of containing the cost for the employer. So something that is portrayed as a very progressive development in the mainstream legal theory, critical legal scholars are showing you by analyzing the decisions that these are the effects of majority of torts decisions. So what is the point of the exercise? Should we throw out torts? So what should we do? But do you see the point that we can develop it, we can change it, we can modify it, possibly, if we first acknowledge that there is a problem. If our story is that it is a progressive development, then nothing more remains to be done. Like no opening happens for critique. So this is the purpose of critique that critical legal scholars are saying, that even if we don't give you another blueprint of what an ideal torts law will look like, at least we have made it, we have put it on the table, so to speak, that there is a problem in how torts principles are operating, or there is a principle in how contract principles are operating, or there is a problem in how criminal law is operating, etc. Once that happens, at least it is open for discussion that here is a problem, deal with it. But if your story is that we live in a rule of law society, rights are protected, state maintains liberty of the people, and we live in paradise, end of story. Yeah. So it's not like what we need to do is educate the judges better or change the laws. What they're saying is that this is a function of a capitalist system of industrialization. And it is the capitalist system that requires these kinds of rights. What kinds of rights? Where the rights holder is an abstract individual rather than with a specific economic class, with a gender, with all sorts of specificities. So one of the claims to fame of the mainstream legal system is that it deals with the legal individual as a legal person and not as a flesh and blood person. Why? Because really we are interested in who does the right attach to. It attaches to the concept of a legal person rather than to you and me as real people. So everyone is a legal person, everyone has the same rights, and everyone is equal before the law. How does that translate into contract law? You have contracting capacity, I have contracting capacity. We enter into an employment contract where you tell me you take it or leave it. Is that equality? The contract law says that yes, it is. That you are autonomous, so is the employer. The fact that the employer is a rich guy and I am not a rich person has been deemed irrelevant by our ways of thinking about rights. Who does it benefit? So this is the point that I'm just giving you very, very superficial examples, but if you read this chapter, this is the detail that you get. And the point of the critique is that how we conceptualize rights is not inevitable, that we can think differently. But one of the criticisms against critical legal scholars is that they only critique. They do not give you an answer. So that is what nihilism is also to a certain extent, and that's what you have been telling me all these days, which is fine. But the point being that what is the purpose of the exercise then? Davis gives you a very good analysis of saying that the purpose of the analysis is to show you that the so-called objective categories are not objective. That objectivity is not possible, that nobody can be objective, that subjectivity is the human condition. If that is so, then we have the responsibility of making sure that our ways of reasoning actually do not exclude people. That we do not have the confidence of saying that we have reached the final answers, but we definitely have the responsibility of acknowledging that how I am thinking, if it has the effect of excluding certain sections of society, then the responsibility is mine to think differently. So one of the things that is a big criticism of critical legal scholars critiquing rights is that sections of society, and remember this is happening in America, African American scholars started saying, it's all very well for you to have your professorships in big universities and tell us that rights are a nonsense. But for us who haven't got all those privileges, rights is a minimum security that we can say that people should live by the rules. Think about it very carefully. So I can be so skeptical about rights because basically I know that I'm all right. But if all I have is that if things get very difficult, at least I want to invoke my rights, and you have taken away that possibility from me, have you created a better set of circumstances for me? So is it any responsibility of yours as privileged legal thinkers to make sure that your thinking actually has consequences that does not make people worse off than what they were before? So it is different than saying that changing the discourse of rights so that now you are also included. So what I said before was that reservation. So, oh, you poor guy, we'll let you into the club, doesn't change the club. But if you take away the concept of equality completely, because that's all rubbish, rights are rubbish, then what has that person who's been exploited on all fronts, do they have anything to fight the system with? So the critique of critical legal scholars then is that you have privilege, you don't even realize that sections of society who are marginalized have not a lot going for them. To take away this very small guarantee of procedural fairness and nothing else is making a bad system worse. So stop critiquing rights if there is no alternative that is available. So does that mean that we should stop doing critique? Okay, so this is the point, that is Davis's point, that the purpose of critique is not to have a revolution, but the purpose of critique is mostly at the level of ideas, and you and I are the ones who are the target of her kind of writing. That is, don't be too comfortable in how you think about law. Recognize that ways of thinking have real consequences, and take the responsibility that we are the ones who have the privilege of thinking about these things, and the consequences of thinking should at least, we should at least strive that it should be inclusive. Maybe we'll succeed, maybe we will not succeed, but the responsibility must be acknowledged that how we do critique, it should open up the possibilities that we think differently. But think differently is not that I can think what I like. No, that consequences follow from our thinking, and we are the ones who are doing it. So why can responsibility be shifted to somebody else? At the moment, responsibility can be shifted to somebody else because I have no part, or I believe I have no part in this state of affairs. So positivism says that, Hart says that, Fuller says that, Dawkins says that. I can rattle that off quite nicely, but I have nothing to do with that. So if the system is unfair, well, go and talk to them. Why are you telling me? While what Davis is getting at is that there is no them. We are the ones who make them the authority. And we are the ones who have to acknowledge that ideas are basically what you and I agree to. And if the consequences of our ideas are inequality, then the responsibility is ours to think differently. You can't completely think differently because we are the product of our context. So we're not sort of autonomous agents, and I think that's been your concern, that here is a system that is oppressive, that is difficult, and I have no option but to be part of the system. There is no outside of the system. If there is no outside of the system, should I stop doing critique? No, at least open the possibility. If sufficient numbers of us are doing it, maybe things will change. But if we choose not to do anything about it, then we perpetuate the system. This is the point that he's making, is the necessity of critique, or the aim of critique. Okay, tomorrow we're reading legal feminism. So can you please, I know you've been very, very good turning up on a Sunday like that. I wish I had the confidence that my students in Sydney would do that. They would never do it. So thank you for coming, and we'll take up the next chapter